We have a major legal controversy unfolding inside the Department of Justice, and it revolves around the future of Attorney General Pam Bondi. Behind the scenes, there is growing anxiety not only about political pressure inside the administration, but also about something that could follow long after government service ends. For many lawyers in Washington, the biggest fear is not losing a job. It is losing the license that allows them to practice law. And right now, that fear is becoming very real for several officials connected to the administration, because state bar regulators across the country have begun examining the conduct of government lawyers who served under Donald Trump. Those regulators are asking whether certain legal strategies used during the administration crossed ethical lines and whether disciplinary action should follow. What makes the situation even more dramatic is that two major developments in the last 48 hours suggest the Justice Department is deeply worried about where these investigations might lead. And the response coming from inside the administration could reshape the relationship between federal lawyers and the state authorities that regulate them. To understand how serious this situation is, we have to start with a specific example that has now triggered a formal investigation. The focus of that investigation is Lindsay Halligan, who briefly served in the Eastern District of Virginia before leaving the position under intense scrutiny. During her short time in office, several federal judges raised concerns about her conduct in court. Some of those judges openly questioned whether professional responsibility rules had been violated. The criticism did not stop when she left the position. Instead, it followed her outside the government. And now the Florida bar has officially opened a review that could determine whether disciplinary measures should be taken. That investigation alone would be significant, but it also represents something larger. It signals that state bar authorities are willing to examine the behavior of lawyers who served in powerful federal positions. And that possibility is creating anxiety inside the Department of Justice, where many senior officials hold licenses issued by state bars across the country. To understand why that matters, it helps to step back and explain how the legal profession in the United States actually works. Every attorney must be licensed by at least one state authority. Passing the bar examination is only the beginning. After the exam, there is another process known as the Character and Fitness Review. This review examines a person's background, finances, employment history, and professional references before allowing them to officially join the legal profession. Once admitted, that lawyer remains subject to discipline from the authority that issued the license. And that authority can investigate ethical violations even years after the conduct occurred. The system exists to ensure that attorneys follow strict professional standards no matter where they work, including inside government institutions. And that is where the current controversy becomes complicated, because the Justice Department has now introduced a proposal that could dramatically alter how those investigations happen when federal lawyers are involved. The proposal appeared recently in the Federal Register, and it suggests that when a complaint is filed against a current or former Justice Department attorney, the department itself should conduct the first review. Under this idea, state bar authorities would be asked to pause their investigations until the internal review process inside the Justice Department is finished. Supporters argue that such a system would protect sensitive federal legal work from interference by outside regulators. But critics immediately raised a different concern. They say allowing the department to investigate its own lawyers creates an obvious conflict of interest because the institution responsible for enforcing the law would also be protecting the attorneys who represent it. The question many legal experts are asking is simple: who oversees the investigators if the investigators are reviewing themselves? That concern has triggered an intense debate inside the legal community because state disciplinary systems were designed specifically to remain independent from political institutions. Their job is to examine misconduct without pressure from employers, political leaders, or government agencies. If federal departments begin conducting their own preliminary investigations, critics worry that independence could weaken. State bars might be forced to wait months or even years before beginning their own proceedings. And by the time they are allowed to act, crucial evidence may already be difficult to obtain. The timing of the proposal has only intensified the debate because it arrived at a moment when multiple government lawyers could soon face complaints related to controversial legal decisions made during the administration. Some observers believe the rule is an attempt to slow those investigations. Others believe the department is simply trying to clarify procedures for handling professional complaints involving federal officials. Either way, the proposal has immediately drawn national attention because it challenges the traditional balance between federal power and state authority over professional licensing. The controversy also reveals something about the internal tensions that have been building inside the Justice Department. Reports suggest disagreements among senior officials over legal strategy policy decisions and public messaging. At the same time, congressional committees have continued asking questions about investigations handled by the department, which has placed additional pressure on its leadership. That environment has created uncertainty about the future structure of the agency and about the role certain officials will play if the political landscape shifts again. But beyond the political drama, there is a deeper issue about accountability in the legal profession. Government lawyers carry enormous responsibility. Their decisions shape criminal prosecutions, national policy, and constitutional interpretation. Because of that power, ethical rules governing their conduct are supposed to be extremely strict. State bar authorities have historically served as one of the main safeguards ensuring that attorneys in positions of influence remain accountable for their actions. Now, the debate unfolding in Washington could determine whether that traditional system remains unchanged or whether a new approach emerges in which federal institutions take a larger role in regulating their own attorneys. For the moment, the proposal remains only a draft rule. It will go through a public comment period, legal analysis, and possibly court challenges before any final decision is made. But the discussion it has sparked is already reshaping how legal experts view the relationship between federal agencies and the state organizations that license lawyers. And depending on how this situation develops, the outcome could redefine how accountability works for attorneys serving in the highest levels of government in the United States.